were not interested in presenting any witnesses. In this case, the chairperson of the EC, Madam Jane Mensah, would not be in the witness box. Prior to that, the petitioner's lawyers, through Mr. Chachuchikata, had opposed, he objected to that. The court had to go on a day's break in order to arrive at a decision. When the judges ruled the last time the court sat, the ruling had to do with the fact that the EC had, the second respondent through their counsel had decided not to present a witness, and the court could not compel anyone to do so. That was the ruling of the court. However, immediately after the court had done that ruling, the petitioner's lawyers indicated that they would be applying for a review of that decision, the earlier decision that was taken on the 11th of February in respect of the refusal of the second respondent as well as the first respondent to present witnesses in the box. Indeed, Mr. Chachuchikata at a point had indicated that the application to get the court to subpoena Mrs. Jane Mensah was so as to enable the petitioner show evidence of some of the vote pardon and other electoral malpractices that took place in the 2020 elections, allegedly so. And again, we are certainly going to see that today, because we have cited that application the petitioners through the lawyers have sent to the court, the application in respect of the review of that decision which was taken on the 11th of February, that that the court said no one could compel a witness to be in the box if the witness chose not to. That's one of the main issues that we expect to be raising. That is the chairman of the New Patriotic Party, Mr. Freddie Blay. Mr. Freddie Blay has been in court from day one. He's always in. He's here with Mr. Gary Nimakon. Mr. Gary Nimakon is the director of elections of the New Patriotic Party, the party under whose ticket the president, who is in this case the second respondent, ran for the elections. And no wonder that since this started, Gary Nimakon, the director of elections of the New Patriotic Party, has always been here. My lawyer Yawapon, as well as some other leading lawyers from the office of the president, they are all arriving at this point in time. The sitting is expected to start at exactly 9:30, and when we begin to see these leading lawyers arrive, so a lot more of them coming in. Mr. Gabi Asari Ochridako, he is one of the leading lawyers of the second respondent. Indeed, he's also been speaking for the second respondent as well. He has also arrived right now, and Madam Sherry Aite, former Minister of State, has arrived, and she is making her way to the courtroom right now, and it will be exciting to have views from leading politicians such as this. But Professor Jane Nana Upokwajiman is she was the running mate to the petitioner, former President John Dramani Mahama, in the 2020 elections. She has also come, and indeed it's instructive to note that from day one she has always been in court. The petitioner himself has been here twice or thrice, but the running mate has been here from day one, or since this election petition hearing started. Of course, Professor Nana Jane Opukwajiman, the first female professor of any university in Ghana, but specifically of the University of Cape Coast, prior to being selected as a running mate under the presidency of Mr. John Dramani Mahama between 2013 and 2017. She was the Minister for Education, and just ahead of the elections 2020, she was selected as the running mate. So she has, she's a very interested party in this election petition, and of course has been representing the flag bearer in the 2020 elections, who is also the petitioner here since hearing of this case started. The case was first filed on the 30th of December, and since then a number of issues have arisen, including the fact that on the very first day of the sitting, the court had to hear an application by the petitioner to amend portions of the petition that had been brought before it. Indeed, there were some typographical clerical errors that were identified in that petition. The court granted that application and allowed the petitioner to effect some amendments to the petition that was filed before it. Indeed, the amendment was in respect of the fact that the petitioner had erroneously stated that the court should annul the results as were declared by Mrs. Jane Mensah on the 9th of December and ask for a rerun, and that rerun would be between the petitioner and the first respondent in this case being the EC, which is not a possibility. Of course, the court identified that as a clear clerical error and granted that application. Subsequently, the petitioner was able to effect the amendments, and hearing then began. During the very early stages of this hearing, the petitioner applied for interrogatories. That was the fact that there were some questions, 12 of them, that the petitioner thought that if asked to, if permitted to ask the first respondent's chairperson, in this case Mrs. Jane Mensah, it would clarify certain issues even before the hearing itself of the substantive case. Indeed,
All right, welcome back. We're having some issues there with back to Abdul Hamimun, who is at the Supreme Court and letting us know exactly what's happening. If you're just joining us, this is Ghana Television, and this is also GBC News, and this is Unique 95.7. If you're on Facebook, it's Ghana Broadcasting Corporation, and it's our coverage of the 2020 presidential election petition. And today is another day. The court gave directives that yesterday that all the parties should file their final legal arguments, and then today, whether those arguments will be heard orally or not, the court will determine that bit of it, and subsequently a date will be given for final ruling. But ahead of that, when the court adjourned to today, that was on Tuesday, there are other things that also came up. The petitioner's lawyer raised two issues that is going to file a review of the ruling on February 11. February 11's ruling stated that the first respondent's witness cannot be in the witness book after the first respondent's lawyers raised an issue that they've closed their case because they realized that according to the lawyer for the first respondents, the petitioners have not been able to prove the case that they came to court with, after the petitioners also closed their case after their third witness gave his witness statement and also was cross-examined. So we're waiting for exactly what's going to happen today to know exactly what directive that the court is going to take, although we know that the court said that they're going to hear, whether orally or not, those legal arguments today.
All right, and I also think the court is going to hear those two
applications
that the petitioners filed. But let's say that sign language interpretation is provided by the Youth Bridge Foundation and the National Council on Persons with Disability. And this morning we have Victor Toku, who is doing the interpretation for us. We're still waiting when the Supreme Court sits on the 2020 election petition. We'll take you straight to the courtroom. But as we always do, we'll be joined by Dr. Kweku Ajiman Budu. He is a lawyer and a law lecturer at GIMPA. He's been helping us with some interpretations of the law and the matters as they have arisen in the Supreme Court, breaking it down for you and I to understand. And so we'll join him as and when we get his signal, and then we'll go back to the courts and join Abdul Hai Moment and Edward Nyaku, who are on the ground there.
I think we have Dr. Kweku Ajiman Budu now. Doc, good morning to you. Hello, Doc. Okay, we don't have him yet, so we'll work around it and get to know exactly where we can have him, and then we'll just pick one or two comments from him that will take you back into the Supreme Court. It's supposed to be at 9:30, so when the time is, he will take you back into the Supreme Court. We'll go for a quick break. Stay with us. We'll be right back.
In the witness box, of course, the chairperson of the EC, Mrs. Jane Mensah, has arrived. Dr. Bosman Asari has stepped out again, as I've always been saying, to accompany her in. And these are the scenes we've been witnessing since the election petition started some 16 days ago. And by 16 days, I am talking of the number of days that the court has sat already. This will be day number 17 by my records. And specifically today, it is very likely that the court will focus on two applications that have been brought before it by the petitioner. The first application has to do with reviewing the decision that the court took on the 11th, I beg your pardon, on the 11th of February in respect of the ruling that had to do with the EC chair not being in the witness box. Indeed, the court had ruled that no witness can be compelled, a witness cannot be compelled to be in the witness box if she or he so wishes not to. Following that, the petitioners had also applied to the court to be allowed to reopen their case. That application was also dismissed. Mr. Sami Jemfi is the communications director of the NDC. Sami Jemfi is one of those who addresses the media. We're likely to speak to him after that. He has just made his arrival to the Supreme Court. He's heading towards the room now. Sami Jemfi is also a lawyer, and he is one of those who speaks to the media and tries to summarize the issues in court from the perspective of the petitioner right after the court rises on almost every occasion. It's a Supreme Court hearing of the hearing of the election petition 2020. It's getting clear that the court will sit soon. When we begin seeing figures and faces like that of Mr. Frank Davis, then you are sure that it's almost set for everything to begin. Mr. Frank Davis, of course, is one of the lawyers representing the second respondent in court today. The lawyer, the lead counsel, of course, is Mr. Akoto Ampao. Mr. Akoto Ampao went into the courtroom some 20 minutes ago. You may have missed that, but Mr. Akoto Ampao is the lead counsel for the second respondent, who in this case is President Akufo-Addo, who ran for the elections on the ticket of the New Patriotic Party. And that is why you'll find that even though individual names are on the petition, there is a lot of political representation even here at the Supreme Court. The two chairpersons for the two parties that are in contention at the Supreme Court today have always been present from day one. Fatimatu Abubakar is one of the spokespersons for the second respondent's legal team. She is also making her entry to the courtroom right now, but of course also going through the necessary COVID-19 protocols before making her way in there. A lot more of the lawyers and spokespersons for the two sides have already gone in. Indeed, this will be the second time in the history of the Fourth Republic that we are seeing an election petition being brought to the Supreme Court. The first was in 2013. That had to do with determining the results of the 2012 elections. Indeed, that election petition ran for 8 months from January until about the last days in August, 29th August, I believe, of 2013 was when the court came out with its final judgment, and the reliefs being sought for by the petitioner at the time. Indeed, at the time, the law had not been amended, and so more than one person could petition the Supreme Court over election results, and therefore it was President Akufo-Addo, who was then the candidate for the New Patriotic Party in the 2012 elections, together with his running mate, Dr. Mahmoud Bawumia, and the then chairman of the party, Mr. Jake Obechebi Lamte, the late. The three of them petitioned the Supreme Court, and the respondents initially were the presidential candidate of the NDC in the 2012 elections, who had then been declared the winner of the elections, Mr. John Dramani Mahama, in 2012. And then they also sued the EC. The EC at that time was chaired by Dr. Afarijan. Dr. Afarijan, of course, supervised the elections in Ghana since 1996. And the last elections he supervised was the 2012 general elections, when he went on retirement after that. And he was one of those who also sat in the witness box. Indeed, some of the arguments, both within and outside court, has been the fact that if there is precedence, then Mr. Afarijan, who was the EC chairperson, was in the witness box, and if the EC was ever in the witness box when there was an election petition, why are they now refusing to be in the witness box? But the court has ruled differently on these things, indicating that a different set of laws have amendments have taken place since then. But it's all set now for the hearing to begin. We will, of course, bring you all the details as and when we have them. And anytime there is any clarification we need to bring to you, of course, we will be right here to do that. We'll go back to the studio and prepare to take you back into the courtroom. My name is Abdulhai Mumin.
All right, welcome back. That's Abdulhai Mumin. We're back here into the studio, and we're going to join Dr. Kweku Ajiman Budu. He's a lawyer, he's a law lecturer, and also the head of Law Center's Gimpa Faculty of Law, and he's joined us via Zoom. Doc, good morning to you.
And how was the weekend?
We are yet to go into the weekend.
Oh.
Look, let's start off with what happened on Tuesday, which was the motion to reopen, or for the petitioners to reopen their case was denied, and a subsequent directive given by the Supreme Court. We can highlight briefly what happened on Tuesday, then we can move into other areas too. Yes.
All right. So the ruling on Tuesday, as you rightly pointed out, was in relation to the application that had been made by the petitioner requesting or praying for leave from the court to reopen his case for the purposes ostensibly to subpoena or issue a subpoena to compel the chairperson of the Electoral Commission to testify in the matter. And this was what arguments both sides, or the petitioner and the respondents, made strenuous arguments on their own behalf in relation to their respective positions. The petitioner was of the view, for instance, that by virtue of the fact that the respondents had closed their case, and also the fact that the first respondent in particular had caused the witness statement to be filed, which was signed by the chairperson of the first respondent, they had relied on that fact, as well as relied on the statement that had been made in affidavits of the chairperson of the first respondent to the effect that the interrogatories that they wanted to serve on the first respondent, those questions contained therein could be asked of her during cross-examination. And so basically they were arguing on the basis of Section 26 and Section 24 of the Evidence Act, that on that basis, which talks about conclusive presumptions and estoppel, where you make a statement and someone relies on the truth of that statement to that person's detriment, you are then stopped from claiming otherwise. So the petitioner was essentially suggesting that they had relied on those statements to their detriment, and so they were now praying the court to reopen or to reopen their case to be able to subpoena the Electoral Commission chairperson to testify in the matter. And obviously the respondents did reply to oppose that particular application, and they also gave arguments why this was not possible. For instance, they talked about the fact that the petitioner was basically trying to adduce fresh evidence that in case law when you want to adduce fresh evidence. And so the court gave its ruling to the effect that the petitioner had not essentially made or convinced the court that they had to reopen the case, because first and foremost, the court suggested that it was the petitioner's own will that they decided to, or they exercised their right to close their case, and they closed their case not because the first respondent or the respondent had filed witness statements, and that in our adversarial system of justice, you must win on the strength of your own case. And so when they closed their case, the assumption is that they had adduced enough evidence to win their case, or they had put forth enough evidence that will make their case. And so it was within the rights of the respondents, pursuant to Order 38, Rule 3E5 of CI 87, to decide not to call any witnesses, despite the fact that they had filed witness statements in that regard. And the court stated clearly that the mere filing of witness statements does not necessarily mean that the person who has filed a witness statement will call that particular witness to testify in that case, and that a party had the right to decide not to call fresh evidence. And that's basically what the court held in that regard. And so the provisions on conclusive presumptions in section 24 and 26 of the Evidence Act was not applicable because of that right that a party has not to adduce fresh evidence, not to call evidence in a case and close their case. The court also talked about the fact that it's discretionary. It's not automatic that a party in a civil suit or the petitioner hearing can just automatically decide to reopen their case. They had to apply to the court. It was discretionary, and the court had a wide discretion in such matters when parties want to reopen their case. But that discretion has to be exercised sparingly, which means that there is a certain threshold that a party seeking to reopen their case has to meet. And this is because the other party or the defendants or respondents in this case have closed their case as well, which means that ordinarily the matter is drawing to an end. All that is left is the written addresses, if need be, and then the judgment being pronounced in the case. But what the petitioner is seeking to do now, after all parties in the suit have closed their case, is to essentially introduce new evidence, because they are praying the court to allow them to reopen their case. And in reopening their case, the main object for reopening their case is to compel, through a subpoena, the chairperson of the Electoral Commission to testify on their behalf, and they suggest that they will then treat her as an adverse witness. And so the court suggested or held or ruled that to be able to be granted needed to meet certain standards. For instance, you need to show you could not have gotten that evidence that you seek to introduce during the earlier stages. Also, you need to show that that evidence that you want to introduce, the case in general. But the court also has to balance a number of things when arriving at such a decision to allow you to reopen your case and to adduce evidence. For instance, it has to balance the accountability of the lawyer involved, the counsel for the party that has closed their case, in the conduct of this case, this accountability thereof, as opposed to the justice of the case. They need to put material or not, that evidence you're seeking to introduce will not prejudice the other parties involved in the suit. So on the basis of all these, the court was of the opinion conclusively that they were not convinced that the petitioner had satisfied those requirements which will enable the court exercise its discretion in their favor to enable them reopen their case. So that was the ruling of the court on Tuesday when the court last sat.
Okay, we'll go for a very quick break, just one or two commercial breaks. We'll be back, and then we'll continue moving to the two applications. First, to review the February 11 ruling and also a still proceeding and what is expected to happen, also having in mind the directive given by the Supreme Court. So just stay with us. We're going for a quick break. We'll be right back.
When you need a shoulder to cry, run on my campaign, so we try was suicide. Yeah, let bygone be bygone. I can't see what the bottom gonna do, we go straight to start. I'll take you to next level. Baby, oh yeah, yeah, yeah. Energy next level. But baby, oh yeah, yeah, yeah.
drunkenness level. Excessive drinking can be detrimental to health. Not recommended for persons under 18 years, lactating mothers, pregnant women, and people sensitive to caffeine. This advertisement has been vetted and approved by the FDA.
In Ghana, the law enjoins all drivers and passengers in a moving vehicle to wear a seatbelt. No excuse is good enough for not wearing a seatbelt. Seatbelts that are fitted in vehicles are adjustable, so please adjust it to suit you. Let it rest as close as possible to the body. As a driver, before you drive off, ensure everyone else, especially children in the vehicle, have fastened their seatbelts. The airbag is not an alternative to a seatbelt because in the event of a crash, only the fastened seatbelt will stop a passenger from being thrown far forward. So buckle up. Stop road crashes now. Stay alive.
This road safety education is brought to you by the National Road Safety Authority.
This advertisement has been vetted and approved by the FDA.
Your waist, all your body, make bazaar. Thank you so much. And they call me UJ. When you need a shoulder to cry, run on my pumping, so we try was suicide. Let bygone be bygone. I didn't see what the bottom gonna do, we go straight to stardom. I'll take you to next level. Baby, oh yeah, yeah, yeah. Energy next level. Baby, oh yeah, yeah, yeah. I'll take you to next level. Baby, oh yeah, yeah, yeah.
At drunkenness level, excessive drinking can be detrimental to health. Not recommended for persons under 18 years, lactating mothers, pregnant women, and people sensitive to caffeine. This advertisement has been vetted and approved by the FDA.
Don't forget the balloons, check. The DJ, check. And the drinks.
Listen, honey, I've got this party under control, okay?
Daddy, don't forget our birthday cake with the sparkly candles. Daddy, are you there?
The party's at 4 p.m., honey. Don't be late.
With the all-new CowPay on the CowBank app and website, you don't have to worry about carrying cash. Just place your order with your favorite merchant and pay with a Visa or MasterCard, mobile money or CowBank account, or scan and pay. Visit the Play Store or App Store and download the CowBank app today. CowBank app. Forget to cash.
CowBank. Forward together.
The Ghana Trade Fair Company, under the Ministry of Trade and Industry and the One District, One Factory Secretariat, welcomes you to the 25th Ghana International Trade Fair, the premier virtual edition, under the theme, Developing New Trade Opportunities Through Digital Channels. It will be 1 month of exhibition and enterprise, offering manufacturers, suppliers, consumers, and various service providers the opportunity to network and make sales. This February, over 500 local and international exhibitors, factories featuring companies under 1D1F, Rural Enterprises Program, Ghana Export Promotion Authority, and more, all on one virtual platform from the 27th of February to the 28th of March. Get access to a virtual networking lounge, allocation of a virtual booth, and enjoy a unique virtual experience. Visit our website on www.straightfairgh.com to register or call 024-446-9451 or 050-001-5587. Don't miss out. Welcome back, and this is Ghana Television. It's our coverage of the 2020 presidential election petition at the Supreme Court. If you check with your time, it's just about 51 minutes past 9. So that's 9 minutes to 10 is the time. And usually the court would have been in session by now, but we're just getting a letter from one of the lawyers for the petitioners, and if I would read, it says that I received a call from the registrar of the court close to midnight, notifying me of respondents' file affidavits opposing petitioners' application for review, soft copies of which had been seen and sent to my email by 11:13 p.m. I forwarded the processes to the lead counsel for the petitioner at 11:30 p.m. in order to allow lead counsel for petitioner reasonable time to factor the said affidavits into his argument in support of the application for review. I would respectfully request that this morning's proceedings be commenced at 11:30 instead of the 9:30. I count on your kind consideration of our request, and this was signed by Tony Lita, and copies have been sent to both parties in this particular petition. So that might explain the delay.
We can't verify this.
Exactly.
It does appear that the delay we're seeing is as a result of this particular letter, and the signals we're picking from the grounds, which we can't verify, also indicates that proceedings may be at 11:30. We wait to see whether that happens or not. But it does appear that the court is not going to sit at 9:30 as it does all the time, and there's going to be some delay. But whatever it is, we are here. We'll be speaking to Dr. Ajiman Kweku Budu. He is a lawyer and a law lecturer at GIMPA.
Look, let's move into new areas now. First of all, we'll start off with the issue raised by the petitioner's lawyer on Tuesday before the court's adjourned to today. That two applications, one for a review, the second for a stay of proceedings. Let's start off with a stay of proceedings. When we talk about stay of proceedings, what are we referring to, and what's the process like? Doc?
All right, so the two applications, as you point out. Yes, can you hear me?
Yes, yeah, we can hear you now.
Can you hear me?
Yes, we can.
I was saying that there are two applications before the court. Like you pointed out, there's one which has to do with the ruling of 11th February, and so it's an application for review of the ruling of the court on 11th February in respect of the notification to the court by the respondents that they would not be calling witnesses So this application that is before the court today, or this first application, has to do with the ruling of 11 February, where the respondents, upon being called upon to open their case, decided that they were not going to open their case and that they were also closing, and that on the basis of everything that had happened so far, they did not feel there was a need to open their case. And so, and the court ruled on that particular application, held clearly that on the basis of Rule 3E1 and 5 of Order 38 of CI 87, which is the High Court Civil Procedure Amendment Rules that amended CI 47, they had that right to not call evidence, and that even though they had filed witness statements in that regard, the filing of the witness statements in compliance with the court's directions for them so to do was not an election to adduce evidence at all costs. Because if you remember, the petitioner was arguing that the filing by the respondents of those witness statements constituted an election, that they had elected that they would definitely call evidence or adduce evidence or open their case. And the respondents, on the other hand, were arguing to the contrary, that there was no such obligation on them because they could choose whether or not to adduce evidence. So the issue that was before the court was basically at what point you elect to adduce evidence, or whether the mere filing of a witness statement constitutes an election to adduce evidence. And the court held that until the witness who has filed a witness statement is put in the box and sworn in, and the witness statement adopted as his or her evidence in chief, it is not evidence that is before the court. And the mere filing of the witness statements did not mean that the person will call that witness, because as a matter of fact, Order 38 Rule 3E5 gives a party in the suit the option to decide that indeed they may have filed a witness statement but choose not to call that particular witness. And in that circumstance, there is also an option available to the other party, in the sense that the other party can then apply to the court to have that witness statement put in as hearsay evidence. And so that is what the court said, that on the basis of that, the parties had not elected to adduce evidence, and they were within their rights to elect not to adduce evidence, and so dismiss that application. So it is in respect of that application that the petitioner has filed an application for review. The petitioner essentially wants the courts to review their ruling in that particular regard, because they feel that a miscarriage of justice has been occasioned and all that. So that is the first application that is before the court.
All right, Doc, just hold on for me at least with the first application. Let's quickly go back to Abdul Hai Mumin at the Supreme Court. We'll pick one or two thoughts from him as to exactly what's happening there, and then we'll get back to you, Doc. Let's move to Abdul Hai Mumin, who's at the Supreme Court.
That's the time that was slated for sitting to commence today has shifted. Indeed, information we are getting from unconfirmed sources indicate that sitting is very much likely to start after 11 this morning. You would recall that the court usually tells ahead of time when it would begin sitting, and the sitting has alternated between 9:30 and 10 a.m. However, the last time the court sat, the indication was that it was going to start at 10. It ended up beginning sitting just before 11. There was about an hour's delay, and at that time we're told it had to do with issues that had to be sorted out among all parties interested behind closed doors. It remains unclear what exactly is causing the delay for today's sitting to commence. However, we do know that there is an application. Indeed, ahead of today, that was on the 11th of February, when the court gave that ruling in respect of the application brought before it to object to the refusal of the first respondent in particular to present a witness in the box to be cross-examined. When that ruling was given, that indeed the witness could not be compelled to sit in the box, the court then proceeded to instruct the parties involved, in this case the petitioner, the first and second respondents, to begin to prepare their written addresses, which they were expected to have submitted on Wednesday, that was yesterday, so the court will sit on the matter today. However, documents that we here at GBC have cited indicate that the petitioner has applied for two things. First of all, for a review of the decision that was taken on the 11th of February, the ruling on the 11th of February in respect of the, if you like, call it the refusal of the first and second respondents to present witnesses to be cross-examined. The petitioner wants that decision to be reviewed. Then there is a second application also that we have been told about, which has to do with the petitioner asking the court to stay on proceedings until all pending matters in respect of its review applications have been heard. These are the outstanding issues that we believe that the court will be dealing with today. However, once again, it is very unclear what has caused the delay in the commencement of today's proceedings. However, what we do know, especially from lawyers and other spokespersons who have been within the courtroom, and I'm sure that you have seen here on GBC platforms the action in the courtroom, where at a point the courtroom appeared to be full to capacity, except for the spaces that have been reserved because of issues of COVID-19 and social distancing, that the court was filled to capacity. At the moment, we will show you the court room right now, and you'll find that people have left, almost all the lawyers have left, almost all the spokespersons have left, almost and a while ago I saw Mr. Ofusampofu, who is the chairman of the NDC. He left the courtroom a while ago in the company of the communications director of the NDC, Mr. Sami Jemfi. He also left the courtroom a while ago. That's an indication that indeed no action is taking place right now. And so we're speaking to some of them on the sides. They indicate that the time for the commencement of proceedings has been shifted till after 11. When we do get an official statement regarding the exact time, we will of course let you know. But of course GBC will continue to be here monitoring every minute detail right here at the Supreme Court. And when we do have that information, we surely will return to you. But for now, I can report to you that contrary to the earlier announced time for the commencement of proceedings today, which was 9:30, the proceedings will not take place. Has not started, of course, but will take place after 11. At least that's what we are told for now. We will return to you with more information. But okay, again, it's instructive to let you know that even though people have left, the lawyers and some of the spokespersons have left the courtroom, they have not left the court premises. We've seen some of them in their cars at the moment, others just standing by and having their own chats. But again, we are not engaging them in any conversations on TV at the moment, because we do not want to preempt the issues that will arise in court. We want to leave that to the court. But what we can report to you is sitting has not commenced. Indications are that it will commence after 11 a.m.
Right, so that was our man on the ground, Abdul Hai Moment. And so I think, George, we can confidently say that this delay may be caused or has been occasioned by that letter that was written by Tony Lita to the courts, which letter reads that I have received a call from the registrar of the court close to midnight notifying me of respondents' filed affidavits opposing petitioner's application for review, soft copies of which he had sent to me, my email, at 11:13 p.m. I forwarded the processes to lead counsel for petitioner at 11:30 p.m. in order to allow lead counsel for petitioner reasonable time to factor the said affidavit into his argument in support of the application for review. I would respectively request that this morning's proceedings be commenced at 11:30 instead of the scheduled 9:30. I count on your kind consideration. And that letter was signed by Tony Litter, solicitor for the petitioner. And so that should cause the delay that we're seeing in court today.
So we're here, and glad that you're all keeping each other company. And we're going to be with you till the time that the justices take their seat to find exactly what's going to happen today. I'll move back to Zoom to join our guest, Dr. Kwekwajiman Budu, who is a law lecturer and the head of the Law Center's Gimpa Faculty of Law. Look, you were on the review process. You were just about making a point before we went for that break from Abdul Haibumi. So you can continue on that, then we'll build on to other areas too.
All right, so I was saying that the application for review has to do with the 11th February ruling of the courts that affirmed the position of the respondents who had decided to close their case and not call further evidence. And that is what the petitioner is applying to the court for the court to review that particular ruling, because they suggest, or the petitioner suggests, that a grave miscarriage of justice has been occasioned because the court did not avert its minds to certain statutory provisions. And that is why the motion of notice for stay of proceedings has also been filed. And what basically that is that the petitioner is praying that the court stays proceedings, as in halt proceedings, until the review application is determined. Because according to the petitioner, not halting or staying proceedings at this point and to continue to the addresses paid, which was the directions that the court gave that the parties should file their written addresses by yesterday, and then today there will be highlights of those written addresses. If the court does not stay proceedings, it would seem as though the review application that the petitioner has filed, which is the basis on which they are praying that the court stay proceedings, has been predetermined. Yeah. And so that is basically why the petitioner is saying that the court should stay proceedings in this particular matter.
Doc, let's look at review in its sense by the Supreme Court, not necessarily going into this particular case, but in the whole sense of reviewing by a Supreme Court, or reviewing a Supreme Court's decision. The possibility of the court itself reviewing its own decision, how high or low is that?
So we know that the Constitution of Ghana is what gives the Supreme Court the power to review its own decision. Mm-hmm. And when we talk about review, we're simply saying that the Supreme Court will be taking a second look at a decision that they have already given. So if you look at Article 133 of the 1992 Constitution, it provides clearly that the Supreme Court may review any decision made or given by it on such grounds and subject to such conditions as may be prescribed by the rules of court. And we know that the rules of court is that body that made, the rules of court committee is that body that made the Supreme Court rules, that sets out the processes or the standards you need to meet in invoking the review jurisdiction of the court. And we'll come to that shortly. But Article 1332 then says the Supreme Court, when reviewing its decision under this article, shall be constituted by not less than 7 justices of the Supreme Court. So at any point in time where the Supreme Court is reviewing or has been called upon to review its decision, the panel that will preside over that particular review application will be not less than 7 justices, which means that and we know the Supreme Court is ordinarily constituted by 5 justices of the Supreme Court. Yeah. So in that instance, the minimum number of justices that will be able to sit on that review application will be 7. If it is 7 as it's in this particular election petition, that is 7 justices are sitting on the petition generally. 2 more justices may be or will be added so that we have an odd number of 9 that will review the particular decision. And that's what we've already seen in this petition earlier on in relation to the interrogatories, where 2 more justices were added to the bench and it was reconstituted. So there was a 9-member panel that sat on the review application in relation to the interrogatories. So we know that the Supreme Court has that power to review its own decisions, basically take a second look at its decision and review it, whether to affirm or not affirm whatever position that has been brought before it. But most importantly, the grounds for review have been provided for as the Constitution mandates by the Rules of Court Committee, and this is contained in Rule 54 of the Supreme Court Rules of 1996, CI 16. And Rule 54 clearly provides that in order to be able to invoke the review jurisdiction of the Supreme Court, you need to come under one or both of 2 grounds. Basically, there are 2 grounds under which you may seek a review of a decision of the Supreme Court. The first ground is that there has to be exceptional circumstances which have resulted in a miscarriage of justice, which means that something grave must have happened in relation to the original ruling of the Supreme Court, which occasions a miscarriage of justice, which means that justice was not done by virtue of the ruling of the Supreme Court. The second ground is that you have discovered new and important matters or evidence, which after the exercise of due diligence was not within your knowledge or could not be produced by you at the time when the decision was given. So these are the 2 grounds under which you may seek or pray the court to review its decision. And so if you look at this particular application for review of the ruling in relation to the 11th February ruling, the petitioner in this case is seeking the review on the following grounds. The first is that the petitioner believes that the ruling of the court in respect of the first respondent not being called to testify was without regard or was per incuriam Section 26 of the Evidence Act 1975. And Section 26 is what deals with the conclusive presumptions or estoppel by conduct, which I believe we've talked about, but we can talk about it again subsequently. And as a result, the petitioner believes that because the court did not have due regard or decided contrary to the provisions of Section 26 of the Evidence Act, it had occasioned a grave miscarriage of justice to the petitioner applicants therein. So you see that the first ground of review is grounded in the first ground on which the Supreme Court's review jurisdiction may be invoked, which is that a miscarriage of justice has been occasioned, that there were exceptional circumstances. So the petitioner here is saying that the exceptional circumstance that occurred within the context of the ruling of 11th February was that the court decided or ruled not having regard to the express provisions of Section 26 of the Evidence Act, which provides that if somebody makes a statement or does something which is supposed to be true or makes you believe it's true or the truth of which is not disputed, and you act on the basis of the truth of that statement, that person is subsequently stopped from moving away from that particular position. So the petitioner is essentially saying or arguing that on the basis of the fact that the chairperson of the Electoral Commission in affidavits before the court, affidavit for instance in opposition to the application for review of the court's decision in relation to the interrogatories, the Electoral Commission chairperson stated clearly that she would be available for cross-examination or the questions that the petitioner was seeking to ask by virtue of the interrogatories, the petitioner could have that opportunity to cross-examine her if the petitioner chose so to do. And so the petitioner is saying that on the basis of that statement, that they acted on the truth of that statement, and so they expected that the respondent or the first respondent will call the chairperson of the first respondent, so that, because there was a witness statement that had already been filed by her, so that that statement that she had made, that the petitioner will have an opportunity to cross-examine her, they will indeed have that opportunity during cross-examination to ask her those questions. So the petitioner is saying that on the basis of their reliance of the truth of that statement in accordance with Section 26 of the Evidence Act, which is on conclusive presumptions or estoppel by conduct, the first respondent was stopped basically, and that they had to call the witness, that's the chairperson of the Electoral Commission, so that she may be cross-examined, because she herself had said so, that the opportunity would come for the petitioner so to do. So they believe that the court, in deciding or ruling in that regard, contrary in their opinion to Section 26 of the Act, the court had acted per curiam without regard to that express provision statute. As a result, a grave miscarriage of justice had been occasioned to the petitioner.
Right. So do we have
the second under.
Hello, Doc. Too bad that we're having some connectivity challenges here. We'll work on Dr. Ajiman Budu's line and get back to him. Sure. He was explaining to us. Hello, Doc.
Yes, I can hear you.
All right.
You were going to say something.
Yeah, we're having some connectivity challenges here, so I just hope that it's better now, though.
Yes, I can hear you.
So you can go ahead.
Yes, no, you were going to ask a question. I believe you asked
so
a question.
I wanted to know whether there is any precedent where a Supreme Court, maybe anywhere in the world, has made a decision or has made a ruling and a review applied for, and that the Supreme Court has backtracked and changed the ruling or the decision that they made. Do you have any precedent like that?
Of course, it's happened. There are numerous cases in which the Supreme Court, even in Ghana, have, upon an application for review, have reviewed their earlier ruling. One typical instance of that has to do with the fast-track case, the fast-track High Court case. You remember in the early 2000s, when the fast-track court was established, and I believe it was Chachuchi Kata who was charged with causing financial loss to the state, and he challenged so there were a number of things that happened, but basically he challenged the constitutionality of the fast-track High Court, and that it was not known, a known court under the courts that we had or established by the Constitution. And so the Supreme Court sat on that particular matter, and the Supreme Court ruled in the first instance that indeed the fast-track High Court was unconstitutional. But there was an application for review which was brought by the state, and so as we've talked about review applications, there has to be a reconstituting of the bench, and so the panel was reconstituted. 2 more justices were added to the initial panel to review that application. On the review application, the court came to a different conclusion, that indeed the fast-track had a new court being established. It was a division of the High Court, and we've seen that subsequently. So it wasn't as though the Chief Justice was establishing a new High Court contrary to what we know to be the High Court within the context of the Constitution, but rather it was a division of the High Court which the Chief Justice was entitled to do. And we've seen subsequently that there have been the establishment of several divisions of the High Court, because the general rule or principle is that there's only one High Court. but there are several divisions. So we have the Human Rights Division, the Commercial Division, the Lands Court, the Financial Crimes, and all that. There are different divisions of the High Court. So that is one example of a situation where the Supreme Court, even in Ghana, has reviewed itself and came to a contrary decision. Does that answer your question?
Very well, sir. So how is court going to look like today when the justices sit? Don't forget that they set today for hearing of the legal addresses. Meanwhile, there are two applications for a review and a stay of proceedings. How is that all going to pan out in court today?
So that's what I was saying earlier on, that the petitioner in their motion for stay of proceedings is basically saying that they are aware of the fact that the court has directed the parties to file their addresses by yesterday and to highlight on those addresses today. But they are applying for a review of the 11th February ruling affirming the position of the respondents to close their case. And one of the bases for which they are applying for that review is that they believe that a grave miscarriage of justice has been occasioned because the court decided or ruled without due regard to a provision of statutes. And so they're saying that to go ahead to file those addresses or highlight on those addresses will be seen or will look as though, in their opinion, that's what they're saying, will seem as though their application for review, which they have brought before the court, which is pending, to take any other step contrary to, or to take any other step aside sitting on the review application will be seen or will seem as though their review application has been predetermined, because they're saying that they are challenging the fact that the respondents could close their case and that the respondents had to adduce evidence. But the court is saying that file addresses, because according to the court, they have ruled on that matter. So parties are supposed to file their addresses. But the petitioner is saying that if the court takes that step, or if that step is taken in terms of the addresses and the highlighting of those addresses, plus the application for review of the ruling of the court to affirm the respondent's position to close their case is pending, it will seem as though their application has been predetermined, in the sense that they believe that the application will be successful. And if the application is successful, what it will mean is that the respondents will have to call evidence. Basically, that's what it means. And it would mean that the whole process of filing addresses would have been premature. So they're saying that we need to stay proceedings, or in simple terms, halt proceedings, or put a halt to those further steps that the court had directed that the parties take until the review application in relation to that particular ruling that the respondents could close their case, until it is determined, because the petitioner believes that their application will be successful because the court erred in the first ruling, which, if the court comes to that conclusion that indeed it erred in the first ruling and reviews itself, what it will mean is that the respondents will have to call evidence, and that extra step of filing addresses and highlighting on written addresses would have been premature, in the sense that the case would not have been done, because the petitioner or the respondent would have opened his case basically, and the case would be ongoing. So that is what the petitioner is seeking to do, and that's why I believe there is that delay, as well as what your reporter talked about, assuming it is verifiable and it is true that indeed such letters have been brought to the court in respect of a response that the respondents had given in relation to the review application.
Right, but to hear or not to hear these two applications, is it discretionary? So the Supreme Court can decide not to hear those applications in the first place. Is that the case?
No, once again, I'll refer us back to a statement that the Honorable Chief Justice made when they were delivering that particular ruling, the ruling of, was it the ruling of the 11th or yes, the ruling of the 11th of February. The Honorable Chief Justice stated clearly, you remember that counsel for the petitioner sought to inform the court of their intention to file an application for review or file other applications. And the Honorable Chief Justice made it quite clear that the court was not responsible or could not determine whether or if parties to a suit before it can file applications. The parties are free to file applications that they see or deem necessary. The responsibility of the court is to sit on those applications and decide the applications on the basis of the merits of those applications, so that vexatious applications or applications that are unwarranted will not be dealt with or will be dismissed, or even if the application has some merit, but the standards that you have to meet in terms of establishing your case to convince the court to rule on your behalf is not met, the court will also dismiss that particular application. So the court doesn't decide whether or if parties will file applications, but once the applications are before the court will sit on that application, and these are the applications that are before the court, where the petitioner is basically suggesting that let's not get to the written addresses yet, because we are entitled to seek a review of your ruling. We're entitled to apply or make an application to the court for it to review its initial ruling. And we believe that we will be successful on that application, so that if we do not stay proceedings and the court decides to go straight ahead to the written addresses for counsel to highlight on the written addresses to aid the court in coming to a judgment, it will be premature in the sense that they feel that the review application will indeed be successful. And if it is successful, it means they will have an opportunity to cross-examine the chairperson of the Electoral Commission, which will mean that new evidence is going to be introduced, which will impact whatever written addresses that they would have and impact the judgment of the court generally in their opinion. And so that's why they are saying that the court should stay proceedings, which means halt any further step until we decide this review application. And so once this application is decided, then the case can continue. That's basically what this is all about.
So as it stands, these two applications cannot be heard post the legal addresses. I just want to be clear that per processes, these two applications cannot be heard post the legal addresses.
That's basically what the petitioner is saying. If you read the motion for stay of proceedings as well as the application for review, basically that's what they're saying. In the application for review, they actually set out that to go ahead to determine or to go ahead to take any further step in this case would be more or less as though their review application has been predetermined, because they're saying, and once again, I want to repeat for emphasis, they're saying that once that step is taken, once they filed an application for review of an earlier ruling of the courts, they are in their rights to a decision or a ruling on their review application. And they believe that the application will be successful. And I'm just giving you the import of if the application is successful, because if the application is successful, and the application is that we want to cross-examine the chairperson of the Electoral Commission, because the Electoral Commission itself, which is the first respondent, elected to adduce evidence. And the statement that the chairperson made gave them that belief that indeed they would adduce evidence, that's the first respondent, through the chairperson of the Electoral Commission. But the court has given the respondent the right to close their case, or affirmed their right to close their case. And that is what they are saying, that it is wrong, and the court erred, and that the court acted without due regard to provisions of the law. For instance, they even say that the ruling of the court was in breach of Article 1913 of the 1992 Constitution. And I want to read Article 1913 of the Constitution so that viewers would appreciate what is being suggested. So Article 1913 of the Constitution, Article 19 generally of the Constitution is on fair trial. Okay. And Article 1913 of the Constitution provides as follows, that an adjudicating authority for the determination of the existence or extent of a civil right or obligation shall, subject to the provisions of this Constitution, be established by law and shall be independent and impartial. And where proceedings for determination are instituted by a person before such an adjudicating authority, the case shall be given a fair hearing within a reasonable time. So basically, the applicant's hearing, that is the petitioner, is suggesting that they are entitled to a fair hearing on the basis of Article 1913, and that the ruling of the court on 11th February was contrary or was in breach of Article 1913, as well as Article 296 of the Constitution, which talks about the exercise of discretionary power shouldn't be done capriciously, arbitrarily, and it shouldn't be done with favor or fear or favor in one party's instance or the other. So basically, they are saying that the court should sit on the application and not take any other step at this point, because to take any other step at this point will be essentially prejudicing the case or prejudicing the applicant, or will seem, in the applicant's own words, that their review application has been predetermined.
All right, so we've seen a letter, and we've read same, of the counsel for the petitioners asking the court to extend the time from 9:30 to maybe 11:30 thereabout. Is it within the rights of a lawyer to tell the court to extend time for sitting?
I mean, we need to understand that we're dealing with the Supreme Court here, and the Supreme Court is the highest court of the land. And so, just as we saw on the last adjourned date, where there was another letter that had been written by the counsel for the petitioner addressed to the Chief Justice, basically requested that they be given an opportunity to highlight or argue further a particular point before the court gave its ruling. We're also seeing here that another letter has been written to a similar effect one way or the other, because if I heard you right, the essence of the letter was that the affidavit in opposition, or they have been served with a response of some sort from the first respondent in relation to the application for review, and they felt that they needed to have some time to consider those, to incorporate in their arguments, if you may, that will definitely be made before the court. And I mean, the court is the Supreme Court, and they can decide, just like the other time we were supposed to start, I believe, was it at 9:30 or 10 o'clock, but because of that there was a delay, and the court accommodated that. I believe the Supreme Court can accommodate, and I mean, we don't want to speculate, or I don't want to speculate as to why there has been a delay, because I believe that at the time where they come out, that will be made clear. But clearly speaking, by the fact that we are not having the court sitting at the time that is said it will sit, means that there is something that the court is considering one way or the other.
All right, look, earlier when we were talking about the review, we had two grounds for that. That's whether there had been miscarriage of justice and new evidence that did not actually play out during the first time. Now, when it comes to stay of proceedings, are there grounds for that one too?
I mean, one of the grounds is what we're seeing before us right now. The fact that the petitioner is clearly suggested, and once again, we need to go back a little bit so that we give it context. The Supreme Court gave specific directions to the parties, that the parties should file their written addresses by a certain date and then come and highlight on those written addresses so that the case can be adjourned for judgment. So by virtue of the court's directions, today was the day that the parties were to, or the parties were to highlight on their written addresses, which are simply arguments that try to persuade the court to give judgment in their favor, to aid the court in the dispensation of justice. So today was the day that the court was going to adjourn the matter for judgment to be delivered on a date that the court would give. But the petitioner is saying here that halt proceedings because I have a pending matter before you. And the pending matter is such that if it is determined, and I believe it will be determined in my favor, it will, for want of a better word, defeat this whole idea of highlighting or filing the written addresses and highlighting on the written addresses for the case to be adjourned for judgment, because once they are successful, new evidence will be introduced in the sense that the chairperson of the Electoral Commission will have to testify and evidence will be adduced in that regard, which must be incorporated or must be considered is delivering its judgment. So that this is one of the grounds that they are suggesting that if you do not halt the proceedings or stay the proceedings at a particular point in time, it will prejudice the entire case because they believe that they will be successful in their application. So, and that's one, and I mean, application for stay of proceedings are made all the time where there are certain matters that you believe if that at that particular point in time, it will sort of mess up or destroy or make nonsense of any further step that will be taken in that particular regard. So that is a typical instance that will lead to the court to stay proceedings and actually determine that particular application that is before it.
All right, and on the issue of reviewing and also having the panel, we have 7 now, and then if there's going to be a review, additional 2, making 9. I'm looking at how the decision, if it will be reviewed at all, will look like, because the 7 already took a decision. Can the 2 actually bring any change at all to the ruling? Or the 7 actually can also change their mind?
I'm not hearing your question.
Okay. I said that when it comes to the review, yes, the panel is made up of 7 justices. So for now, we're going to have 2 more, making 9.
Precisely.
Yes. So I'm going to look at whether the 2 can effect any change at all that can change the earlier ruling, or the 7 can decide to also change their mind.
And I mean, it's possible, and I mean, I don't want to preempt anything that's going to happen, but basically, when there's such an application and the court or the panel is reconstituted, there's new argument, because remember, the grounds that you're coming under, you are saying basically that, 1, that the court occasioned a grave or a miscarriage of justice. And secondly, so you're also saying that there was some new evidence, or you may be saying that there's some new evidence which did not, or through due diligence, could not have come to your attention at the time the court gave its ruling. So the court is going to listen to your arguments, listen to this new evidence, if any, listen to your arguments in relation of the miscarriage of justice. So that, I mean, if the court at the end of the day is convinced, because you're saying that, for instance, in this particular application, the petitioner is saying that the court decided or gave its ruling on 11th February without regard to Section 26 of NRCD 323.
Yeah.
So if the court agrees with that, if the argument is made and the court agreed that indeed the judgment was per incurium Section 26, it may decide to change its mind. And it's possible for justices to give one ruling at one time and change their mind subsequently on an application for review, or even if it's a different matter comes again before it. It happens all the time. Judges can and do change their minds. A typical example of that, which doesn't have anything to do with review, but just gives you a sense of the possibility that judges do change their minds. The case of MPP and President Rawlings. It was a case in the 1990s, 1993, thereabout, where the New Patriotic Party brought a matter to the Supreme Court. Basically, I believe that was a case that had to do with the district assemblies or so, if my memory serves me right. But the import of the case was that the then President Rawlings was sued as President Rawlings, and there was a preliminary legal objection filed by the state, basically to the effect that you cannot sue under the Constitution, you cannot bring an action against the president in his personal capacity, because the president had certain immunities under the Constitution which made him immune to lawsuits of that nature. That doesn't mean that you can't challenge the acts of the president, because under the Constitution, he is one of the people who may do certain things that may be challenged in the Supreme Court. He may act unconstitutionally, and the Supreme Court can declare that he has acted unconstitutionally, but you cannot bring the action against in that capacity. It has to be at the instance of the Attorney General. And the court held in that regard that indeed, on the basis of the Constitution, the president could not be sued in his personal capacity. And I believe it must have been a 5-4 decision or something to that effect. But one of the justices who ruled in that regard, that indeed you could not sue the president in his personal capacity. In 2001, 2002, thereabout, there was another case which was called Amidou and President Kufuor, where President Kufuor, who had been sworn in, was now also being sued ostensibly in his personal capacity, and I think that had to do with appointment made in relation to the office of the president or something to that effect. And the justice or the judge that had in the MPP and Rawlings case held that the president could not be sued in his personal capacity. In the Amidou and Kufuor case, even though the court essentially reaffirmed the position of MPP and Rawlings, changed his mind, and he actually said that he had had time to consider his judgment, and that in the MPP and Rawlings case he held this, but he had changed his mind, and that it was possible under the circumstances of that present case that you could sue a president in his personal capacity. The point of this illustration is to show that indeed it is possible for judges to change their mind on the basis of arguments that are made, superior arguments that are made. So it is entirely possible that a court can give a ruling on a particular matter, and on an application for review, even though those same justices that gave the ruling on the first mentioned matter or the initial application are still on the matter, and maybe 2 extra justices have been joined on that particular matter, the decision can actually change. And that's what happened in the fast track case, which I cited earlier on, as possible. So it's entirely possible that on the weight of the arguments, that the justices that even ruled in a particular regard may change their opinion and overturn themselves, if you may, or review themselves and change their decision in that regard. But it must have to do with the arguments that are made, backed by law.
Okay.
That will make the judges change their mind, because judges decide on cases on the basis of the law that is applicable at that particular point in time.
All right, we'll go for a quick break, Doc. When we return, we'll talk about the written addresses and what really actually goes into it, just for us to have an understanding of what a written address is and whether there's a particular format for having such an address, and whether a written address will have any effect at all on a case. Doc, we'll go for a quick break, so stay with us, and we'll be right back after this break.
let's throw that to cry. Run on my pampe, so we try was suicide. Yeah, let bygone be bygone. I didn't see what the bottom gonna do. We go straight to stardom. I'll take you to next level. Baby, oh yeah, yeah, yeah. Energy next level. Baby, oh yeah, yeah, yeah. I'll take you to next level. Baby, oh yeah, yeah, yeah.
I don't code this level. Excessive drinking can be detrimental to health. Not recommended for persons under 18 years, lactating mothers, pregnant women, and people sensitive to caffeine. This advertisement has been vetted and approved by the FDA.
Oh, Charlie, that's my friend over there. Hey, Azoto. Hey, Azoto. What's up? Charlie, how?